Good afternoon. Hi, it's Jeffry Adest. I'm here with Sandy Jensen to talk to you today about the exciting topic of FTCA. As you probably know, the new application came out, and I guess consistent with what HRSA does, they changed it from last year. Last year was very significant changes from the year before. This year there are not as significant changes, but there are some new changes that go with it. Sandy is going to walk through the details of what needs to happen, but at a high level, just wanted to point out a couple of things. As we go through the presentation, we will tell you about what is new and what's different from last year. There were also some things that HRSA said needed to be done, and we actually got clarification from them, and they kind of backed down because they were going very far afield of the compliance manual. We are also going to address today, in early 2019, HRSA put out a new FTCA site visit protocol, kind of like the site visit protocol you have for an OSV, but they've put one out now specific for FTCA, which goes much further than the compliance manual and much further than, frankly, I think anything they're allowed to be doing. But they're the government and we can't stop them. So although today is really focused on the application, we're going to talk about some of the things in the site visit protocol as well, because if you are going to have a visit from them, a site visit from them, while they will give you some time to prepare, they generally talk about giving you, that they'll tell you in the beginning of the year, and they generally do their visits between May and October. And we actually have someone having a visit this year. Some of the things they want you to do are not necessarily things that you could come up with in the short window that they give you. Basically, as you'll see when we go through it, some of the things they want the board to have done, and they want you to have policies in place and be able to demonstrate not only that you have the policy in place, but that you follow the policy. And so if they tell you on, February 15th, 2020 that they're coming on May 15, 2020, while, as you all know, we'll do everything we can to help you get ready, some of the things will be very difficult to do to be able to show that you put the policy in place and carried it out. So I'm not suggesting that you have to do everything that we're going to talk about today from the manual, for the precise protocol, but I am suggesting that you think about it, and that if you want to have a separate conversation with us, we can help you with determining these are the things that are easier to implement, or these are things that I do anyway, I might as well start taking credit for it while I'm doing it now, rather than having to scramble at the end. Okay, so just a very broad overview, right? FTCA, as you know, is your essentially medical malpractice coverage, right? Basically, if someone wants to sue the FQHC or its employed clinicians for malpractice type actions, they cannot sue you. They have to instead sue the federal government. You are deemed to be an employee of the federal government for this purpose, and that goes so far that even you're not even a defendant in the case, and the judgment is not a judgment against you. They could choose, HRSA or the U.S. Attorney's Office could choose to notify the physician data bank if they think it's a very bad claim against a physician. It's very rare that they would do that. We're focusing on the application today, but I just want to point out a couple of things. With regard to people who are contractors rather than direct employees, there's very limited circumstances where they would be covered for FTCA. So, for example, if you contract with a hospital to provide you with cardiologists for 2 sessions a week, you will still have FTCA coverage for the cardiology, assuming you added it to your scope, but the hospital and the cardiologist will not have coverage. The only exceptions where someone who you're paying on an independent contractor or 1099 basis would have coverage would be if they're providing primary care. So primary care is like family medicine or adult medicine or pediatrics, and they actually include OBGYN in primary care. So if you have a direct contract with Dr. Smith to work for you as a pediatrician 1 day a week and you're paying him on a 1099, you can have there could be coverage for him, assuming you have the right language in your contract. By the way, although this probably won't be in the slides because we're not addressing this, one of the things that HRSA will be looking for if they do an FTCA site review is all your employment contracts and your 1099 contracts. So they will be looking for that. So for those of you who don't have contracts, you may want to consider having them or making sure you have a very strong job description that will satisfy the HRSA requirements. With regard to volunteers, we will talk about at the end. There's a separate process for applying for FTCA for volunteers. They will not be included in your general FTCA coverage. So at this point, I'm going to turn it over to Sandy to start walking through, and I will jump in with comments as she's going through the requirements.
Okay, great. I think Jeff touched on the overview of the FTCA, so we can move on to this slide. So, we talk about this every year. Every year, FQHCs have to submit an original and then an annual redeeming application to continue their FTCA coverage. And so this year, you can start submitting your applications on May 17th. The system opens them, but they're due on July 1st or on or before July 1st. And as you recall, HRSA released their compliance manual in 2017, and it clarified and changed a lot of the requirements that were previously required in past years' FTCA application. In some ways, it made it simpler, but then you also have to look at the requirements of the PAL, and as Jeff pointed out, they seemed, for this year, to go beyond the compliance manual on some points. So, and again, they're also allowing the opportunity to apply for coverage for your volunteers, and we'll go through that later.
Okay, just a quick thing relating to the application. When you submit the application, they're supposed to notify you. There's supposed to be something coming back to the HB saying that they've accepted it and it's complete, or that they have not, which is supposed to come back within 10 days after you submit it. So make sure you're checking for that. If they send something back to you saying it's incomplete, you only have 10 days to get them whatever they think is missing, and if not, you could lose your coverage or have to reapply from scratch, which would mean you'd have a period where you would not have coverage until you submit a brand new application. So make sure you're following up in the HB. You should be checking the HB on a regular basis anyway, but make sure you're following up with regard to this so that they don't come back and say, we told you there was something wrong and you missed it.
And similar, they did say that if you fail to submit by July 1st, then you've lost your coverage and you'll have to submit a whole new application, and then you'll have that period of time that you won't be covered. So like last year, this year's application includes many yes or no questions. A lot ask that you attest that you have policies and procedures in place, which seems to be a great thing because it seems easier for the application process. But as Jeff mentioned, in 2019, HRSA released the FTCA site visit protocol. It's available on their website, and you should take a look at it. It's really extensive. It requires submission of policies and procedures demonstrating compliance with the FTCA application, and policies and procedures that go beyond what they ask for or even describe in the PAL or in the compliance manual. So, and I'll give you some examples of it later on. And also, they had a technical assistance webinar to explain the FTCA site visit. And an important thing with an FTCA OSV is they'll be looking at your staff to have them demonstrate how you implement those policies and procedures. So it's not enough that you have them. Staff have to be aware of them and they have to implement them. So they'll ask you to go through, for example, a dry run of how you would track a lab or diagnostic order. So from the initial order to receipt and follow-up. So we'll be talking about the FTC site visit as well, but you have to keep that in mind. HRSA also clarified that all supporting documentation that is uploaded must be from this calendar year or 2018, and anything else would be rejected.
Right, so that's important. In the past, we have people come back and say to us, well, I have stuff from 2 years ago I could submit. They're being very clear now that it's got to be from 18 or 19. I guess the positive thing is that they are allowing from 18. So, for example, when we get to training, if you haven't finished your training in 19, you could show them that you did it in 18, but it's got to be 18 or 19.
So again, this year's application is broken down into 4 sections: risk management, quality improvement, quality assurance, credentialing and privileging, and claims management. In several of the sections of the PAL, the HRSA notes that health centers have to disclose whether they currently have active conditions or any enforcement actions on your award. And they note that presence of certain awards, conditions, or enforcement actions may demonstrate noncompliance and may result in disapproval of deemed status.
Right. So if you have a condition right now about anything relating to any of the topics we're going to talk about today, please contact us as soon as possible, because we got to get a condition lifted before July 1 or have a plan for it so that they don't come and reject your FTCA application based on it.
Okay, and they stress that your application has to be signed electronically and certified by the executive director or CEO.
Yes, so if you are the CEO, make sure you're not on vacation the last week when we have to submit it, or make sure you submit it earlier.
Okay, moving on to risk management. And unfortunately, like the prior year PALs, most of the changes made were to risk management. So this is not new that FQHC must designate an individual responsible to oversee the risk management program. The risk manager has to complete annual healthcare risk management training. And with respect, in relation to the FTCA site visit protocol, they explain that they expect to see a progression in training. So if you take level 1 the first year, they'd want to see that you've taken level 2 the next year. And they suggest ECRI. It's a little bit difficult to find where these trainings are on the ECRI website, but you should contact their customer service. I think it's located in the non-FQHC training section. New this year, FQHCs have to upload evidence that the risk manager completed the training in the last 12 months. So for ECRI, I know that a certificate is issued, and you would just upload the certificate.
Right, so that's very important, because I think many of the risk managers, last year when this new requirement came out to have the risk manager and have the training, did the ECRI training, and most likely that's going to be more than 12 months ago. So you now need to go back and get additional training. It could be a different level, like Sandy said, on ECRI, or it could be something else. And if you need help with it, you could contact us, but you have to have training within the last 12 months, not from today, the last 12 months from when you submit the application. So if you don't submit it till the end of June, that means you had to have had your training after July of 2018.
So you have to submit the risk manager's job description. And new this year, HRSA stresses that the job description has to state that risk management activities are a part of the risk manager's daily responsibilities. And in fact, for a number of the job descriptions that you have to upload, that's a requirement for those job descriptions as well.
Right. So what's not really clear here is, do they literally have to have the words daily in that, or is it just that you have to have a job description that makes clear that you're responsible for risk management? For the FTCA site visit protocol, they seem to say they want to see day to day or daily in there. Okay, so that's a pretty easy fix or change. So I would go ahead and try to put that in, add the word daily someplace into the job description.
So like last year, you have to attest that you have a risk management program, and the program has to address risk management across the full range of activities, including triage, scheduling. That means having available sick visits and availability in your schedule for walk-ins, what you're going to do with missed appointments, intake, and tracking and follow-up. So for the site visit protocol, it requires that you submit written policies on these activities, and they gave as example your phone triage policy, your no-show appointment policy, or your walk-in patient policy. And I know one question that was asked was, what if we have procedures but we don't have a written policy? And the response was, submit each document that they asked for.
Right. So this is an example of them going far afield in the site visit protocol for FTCA because, as you all know, there is no requirement in the compliance manual that you have any of these policies. You have to have a way of dealing with them, but you don't have to have policies. But this is part of what I was talking about before. If you have procedures for it, not necessarily for this application, but if you want our help to turn what you're doing into an actual policy, we can help you with that, and we have sample policies for these.
Right, exactly. So this, for the FTCA, you just have to say, yes, I have a risk management program that deals with it. But for the site visit, you actually have to submit all these policies, and then they'll want to see that staff are aware of it, they're implementing it, and they're doing it according to your policy.
By the way, just the slides, for those of you who've been on before, you know we'll send you the slides after. I'm not really sure why it works this way with our webinars, so we can't send it to you in advance, but we will send you the slides after, so you don't have to be sitting and writing down all the words that are on the screen.
So your risk management program has to include risk management training for all staff. There's required elements that have to go into your training plan, and they added some additional training requirements as well that'll be discussed in a little bit. Completion of quarterly risk management assessments and annual reporting to the board. So the compliance manual and the PAL require that the report include completed risk management activities, the status of your performance relative to your goals, and proposed risk management activities that respond to high risk. But the site visit goes a step further and calls it a comprehensive report that also includes completed risk management assessments, number of incidents, and trainings. So a summary or a discussion that touches on each of those points.
Right. I'm not aware of anybody, we've helped a lot of organizations prepare for their OSVs. I'm not aware of anyone who's actually listing out the number of incidents and things like that. So this would be a significant change. Again, it's information that you have. And so if you're going to do a risk management report to the board between now and when you submit the application, which I imagine most of you are going to do because you probably haven't done it and need to do it now to be able to say, to check the box for the PAL, for the application, it might make sense to throw this information in as well.
As last year, the 2020 FTCA application requires you to upload your referral tracking policy, hospitalization tracking policy, and lab and x-ray policy. HRSA has made available on their website an FTCA Deeming application TA resource document. The link is provided, and again, you'll have the slides afterwards if you want to check it out.
Right, but just understand that what's in that document, again, is much more than is required. There's a lot of just recommended in there, so you don't have to follow everything that's in there. If we have reviewed your policies and updated your policies in the last year, then you're fine. This is just a resource in case you're looking for more information.
Your hospital tracking policy requirements. So hospital tracking system has to include patient information, date of admission or visit, date of notification, reason for the visit if known, document you received back from the hospital, and documentation requested, including the dates requested. In prior years, the FTCA application required that you track policies, and your tracking policies include notification of hospital admissions and emergency department visits for those people that you've sent to the hospital, but also for those who entered the hospital on their own. And the compliance manual changed this by requiring that FQHCs risk management procedures only track the patients that you sent to the hospital, not that were admissions that were initiated by the patient. But this year's PAL seemed to go back to the old standard and required FQHCs to upload hospital tracking policies that include both, so those ordered by health center providers or initiated by the patient. And they also during the FTCA webinar, this is not in the PAL, but during the webinar that explained the PAL, they stated that the hospital tracking policy should include tracking all urgent care visits. So we reached out to HRSA and got clarification on this, and which they basically acknowledged that they went, well, let me put it this way. They said that tracking hospital admissions where the patient initiated the visit and tracking urgent care visits were best practice and not necessarily required.
Right. So we're not telling you that you need to be doing it, right? I still feel strongly that the manual says only if you sent the patient, and that's all you need to do. But just letting you know that HRSA has taken the position that you have to go further than that. But like Sandy said, when she pushed them, they backed down and said it's just the best practice. So just something, if you hear it from somebody else talking about it as a requirement, or if you listen to the presentation or you get the slides and they talk about it, just understand that that's just the best practice, not a requirement.
So for referral tracking policies, so not much has changed here. During the FTCA site visit protocol, HRSA noted that the policy should include a discussion about urgent referrals and routine referrals. So if you have different processes or procedures, the referral tracking policy should note the process for each. As in last year, the elements that have to be tracked include the referral type, whether it's specialist or patient-initiated, how it was initiated, by whom, and the process, the frequency of follow-up, who the party responsible for follow-up is, if you have this delegated to a referral department or a medical assistant, documentation of follow-up activities, patient follow-up, patient compliance, so if the referral isn't completed because the patient hasn't complied with the referral. Status reports are just tracking and logging what's going on. The referral tracking policy must also include documentation in the patient's medical record. So you have to also document in the patient's medical record your follow-up efforts, missed referral appointments, frequency of attempts, and attempt methods.
And this one is a hard one for a lot of FQHCs. I'm not going to get into the specifics with so many people on the phone, but if you need help with this, reach out to us, because most places that are doing the referral tracking, if they're doing it, are just doing it through a separate document, not necessarily in the patient's chart. And we could talk about things you can do to achieve this goal.
And also to stress again that you should be doing something, because in the event of an FTCA site visit, they're going to actually want you to demonstrate your procedures for it. So not enough to just submit the policies, you have to show them how you do it. So for diagnostic and lab test tracking, you have to track both, and your policies actually have to include both. So you have to specifically have the words diagnostic testing and lab testing. The tracking elements must include patient information, date the test was ordered, the ordering provider, the list of tests ordered, the date test results were received, provider who reviewed the results, follow-up, and communication of results to the patient. You have to define normal, abnormal, and critical values and the time frame to communicate the results back. So all results, including normal results, should be communicated back to the patient. And other issues to address in the policy, how to communicate the results back. So for example, for abnormal results, are you going to call? How many times are you going to call? And then, I've seen where after so many attempts, then a certified letter goes out. Or for critical values, you would make a few calls during the day, and then if the patient gave consent, you'd contact the emergency number. You have to put that all down in your policy. The policy also should include how to contact the backup provider. So if the ordering provider is on vacation, what's your process for having a backup so that test results are received and communicated back timely? You have to document patient contact attempts. So if you called 3 times, somewhere in the record, there should be documentation of those calls you made. Audits, it has to go back to QI/QA and to make sure that this is being done and any changes to the process that might be needed are implemented. So in 2020, again, the FTCA application requires FQHCs to attest that you have risk management operating procedures. And the operating procedures have to include identifying the areas, activities of highest risk, and mitigating those high-risk activities, including through supervision and establishing or using clinical protocols. So for the FTCA site visit, they actually are going to ask for a copy of your clinical protocols. They want to see what you have in place. And some, ways to identify the areas or activities of highest risk include, looking at your incidents or any claims, or, some areas you can pretty much determine are your areas of highest risk. Like they've identified like OB and dentistry.
Right, and when you're doing these things, it's a good idea to actually use their words. So if you want to take the words that are on the slide, and when you're just doing something that fits into it, try to use the exact words that are here. That's important. Clinical policies, clinical protocols is something that's come up over the past few OSV surveys we've dealt with. Where in the past they never really looked at it. Now they want to see that you have some protocols. It could be that you make reference to ACOG or to some other, societies or up to date or things like that. But you need to have some actual protocols, and they've become much more of a stickler about that.
Your operating procedures should also include documenting, analyzing, addressing clinically related complaints. So what is your process for receiving complaints? Setting and tracking risk management goals. Now, those are annual risk management goals. So if you set your goals last year for 2018, remember that you have to do it again for 2019. You have to develop an annual healthcare risk management training plan. So if you had a 2018 training plan, you need a 2019 training plan.
Right, and just on the goals, right, these are goals that not only do you have to develop, you have to have approved by the board. So if we're on April 30th and you have to submit this application in the next 2 months and you never had the board approve any goals for this year, reach out to us and we will help you come up with a creative solution.
And remember that you have to submit your risk management report to the board that talks about your goals for 2018 and how you did. And so, so let's say your goal for 2018 was to decrease complaints in the area of patient satisfaction. Your report to the board for this year should say, okay, we had 2 less complaints in the area of patient satisfaction. So you achieved your goal in that area. Operating procedures also include developing, I already talked about that, the risk management training plan and your annual risk management report to the board and key management staff that I was referring to. So with respect to training, you have to attest that you have implemented an annual training plan that incorporates obstetrical procedures, and they again include continuing education for electronic fetal monitoring and dystocia drills. But new this year, they require that FQHCs that provide obstetrical services through your own providers, health center providers, need to include obstetrical training as part of your training plan. And they say that this includes health centers that provide prenatal and postpartum care through your own health center providers, even if you don't provide labor and delivery services.
Right, so that's pretty much, well, I don't want to say all of you, but most of the FQHCs on the phone, to at least to my knowledge, provide some OB-related services. And if your doctors are doing deliveries or have hospital privileges, usually the hospitals require some training to condition those privileges. But if they don't, then you need to make sure that the generic training you provide for all providers will not be enough. You need to have specific training for the OB department. Now, if you're not doing deliveries, you don't have to necessarily do dystocia drills, but you still need to do some OB specific training. And again, if you want to reach out, we could talk to you about what that could include.
In addition, for infection control, they added as an example that your infection control training should include dental equipment sterilization, if that applies to you. Again, HIPAA medical record confidentiality is important, and they added as a new requirement specific training for groups of providers that perform various services that could lead to risk, and gave as example dental, pharmacy, and family practice. So this would be specific to those departments or areas and would address those areas that pertain to them. So the training plans have to incorporate all of the trainings outlined in the prior slide. It must document current or previous calendar year trainings, and any other documents outside the state will be rejected. In the 2020 application, you'll be required to upload your current risk management training plan for staff members. It should say your 2019 FTCA training plan, because it has to be an annual training plan. And last year, you guys submitted your 2018. So you would submit your 2019 or your 2020 for next year. The training new this year, you have to submit your training plans also have to document completion of all required training. So last year you had to just submit sample tracking documentation methods or tools, so a blank sign-in, sign-out sheet or an Excel spreadsheet with a list of your staff and the trainings. You still have to do that, but this year your training plans have to document completion of the training. So for training, staff attendance and completion have to be tracked. It must be a part of performance reviews and credentialing and privileging. Your training plans also have to have a process for handling those staff who fail to complete the required training. And again, your risk manager has to complete risk management training in the last 12 months. So risk management assessments. The 2020 PAL requires you to upload documentation that you have completed quarterly risk management assessments. So you always had to do these assessments, but now you have to actually upload them as part of your application. And examples they provided in what you should review to complete these assessments of how you're doing, how your activities are working within your health center would be to look at data, trends, any reports in your risk management committee minutes. So what are the governing board requirements in relation to risk management? The governing board has overall responsibility for risk management, authorizes the risk management plan. They have to receive and review the annual risk management report, make any recommendations on follow-up. And the 2020 application requires the FQHC to upload the most recent report to the board, which incorporates all of the elements in the bullet above. But also you have to upload proof that the board received and reviewed the report. For example, board minutes signed by the board chair or secretary, and the minutes should reflect, should state that the annual risk management report was presented to the board, you know, any discussions that were had over it, or a brief summary or discussion about any proposed activities going forward.
Right. So it's very important. Just having those minutes attached to the board minutes is not enough. It needs to be something in the board minutes saying that the board received and reviewed the report. And it would be wonderful if there was also something in the minutes saying that based on the report, the board said to do X, Y, and Z. So if you can come up with that before and have the board approve it, that would be great. But at the very least, it has to say that the board reviewed and received. Those words got to be in the minutes.
So we just want to talk briefly about potential areas of focus with respect to risk management, and that includes failure to obtain consent or medication errors, failure to follow up, technical failures, things that happen on a day-to-day basis and that could lead to risk. And how do you mitigate risk? Some strategies include performing an assessment, developing a relationship with the patient, responding promptly and actively to alarm symptoms, getting help establishing open communication between providers and supervisors, provide a clear and honest account of events with an appropriate apology.
Right. So just something we do a lot of risk management training for providers. We actually do out and do real life case studies and have them jump in with what went wrong and things like that. But as part of that, I talk to them a lot about is there's a natural inclination in healthcare and in the rest of the world, for that matter, that when you screw up, you try to hide it and hope that no one will find it. Right. So as part of FTCA, part of what they're looking for is for you to find those things and be able to talk about it through your risk management and QA meetings. But they're also, in our experience now, depending on how bad the screw up was, oftentimes if you have a conversation with a patient, it's a relatively minor thing, you can make it go away before you get to the stage of having to have the lawsuit and having a nasty letter from the attorney and things like that. So it's not, I think it's important to train your providers to be forthcoming with the information, and part of getting them to be forthcoming is them understanding they're not going to be sued anyway because of FTCA, but that if they don't come forward with the problem and the government ever finds out about it, they're much more likely to lose FTCA because of it than for actually coming forward and disclosing the issue.
Okay, and so here are some additional examples on ways to mitigate risk.
Right. By the way, again, if you've listened to the webinars before, you've heard this, but any meetings that you're having that you would call QA should be called QA/risk management or vice versa. Make sure that whatever meetings you have, you're getting the words QA and risk management in, because the line between QA and risk management is very thin, and you might as well take credit for both of them in the same meeting since you're having the meeting anyway.
Right, our plans usually say risk management is a component of QA, so that it's clear that they work together. Moving to QA, since we talked about it. So new this year, every year you are required to upload your plan. And this year you don't have to do that. You are only required to attest that you have board-approved policies that demonstrate a QI/QA program. And you have to attest that you have QI/QA operating procedures that include adherence to current evidence-based guidelines, standards of care. You have a process to identify, analyze, and address patient safety, adverse events, and implementing follow-up actions. Your procedures also have to include a process for assessing patient satisfaction and for hearing and resolving patient grievances. Your procedures have to include completion of periodic QI/QA assessments on at least a quarterly basis, and for modifying services based on findings of the assessments. And finally, the procedures have to include producing and sharing reports on QI/QA to support decision-making and oversight. So this is sharing reports with the board and key management staff. You do have to upload documentation that you have performed QI/QA assessments, and they could include reports, committee meeting minutes, or actual documents that are called QI/QA assessments. Your QI/QA assessments have to be completed on a quarterly basis over the past calendar year, and they have to include assessing how if your providers have adhered to current evidence-based clinical guidance, standards of care, and standards of practice, and identification of patient safety and adverse events. The QI/QA assessments have to be done by physicians or other licensed healthcare professionals under supervision of physicians, and they have to be pulled from data systematically collected from patient records to ensure compliance with guidelines, standards of care, and standards of practice. You also have to upload this year the most recent QI/QA report that has been provided to key management staff and the governing board. This too has to be from the current year or previous calendar year. And you have to submit governing board minutes or other documentation that demonstrate the report was shared with and discussed with staff and the governing board. And the minutes should include, again, like the risk management report, it should include a specific reference to the report that was uploaded as part of the FTCA application. Under the compliance manual, it's up to the FQHC to determine whether the person in charge of QI/QA is an employee or contracted, employee full-time or part-time, or whether this position is combined with another position. So the QI director could be the risk manager as well. You could combine it with another position. The person who is in charge of QI/QA doesn't have to be a clinical person, but remember that the assessments must be done by clinical staff. You have to upload the QI/QA director's position description. And so the bullets that include the job duties, ensuring implementation of and updating QI/QA operating procedures, completing of assessments, and monitoring outcomes, those words should be included in the job description. So just take those bullets and make sure they're in your job description. And this is another one where the job description has to clearly state that the QI/QA activities are the part of the individual's daily responsibilities. Like last year, you have to indicate whether you have implemented a certified EHR and that you have systems and procedures in place to protect confidentiality. The QI/QA report must be provided to the board and key management staff. This is in relation to governing board requirements. Your board meeting minutes have to document that the report was shared and discussed by the board to support decision making. And the compliance manual requires that the QI/QA policy be reviewed by the board at least every 3 years. I see occasionally plans that have the board reviewing the policy every year, an annual review. And this was a change with the compliance manual 2 years ago. So you would just want to change your plan so that you don't have to bring it before the board every year.
Right. It's very important from a HRSA perspective, and the reviewers have been very clear about this. If they have a standard that says once every 3 years, that you have a policy that says once every year, they feel like it's open game for you to. When they come in and now you have something from 2 years ago, they're going to say you're out of compliance, because even though you're in compliance with the HRSA manual, you're not in compliance with your own policy. So if you want to be aggressive and bring it to the board every year, that's fine. Just don't put into the policy that you have to, so that if you miss it, you don't run into trouble.
Okay, moving on to credentialing and privileging. So this year you have to attest that you have implemented a credentialing and privileging process and operating procedures that meet the requirements of the compliance manual. You also have to upload your procedures, and they have to include all of the elements listed in the FTCA application and the compliance manual. And HRSA specifically said that if it's not included in your policy, they're going to interpret it that you are not implementing those procedures, so that you're missing components and it's not in compliance with the manual. So your policies and procedures must include all the required personnel, so the licensed independent practitioners, the OLCPs, and also the OCSs. And sometimes health centers just miss that last category that was added by the compliance manual. And these would include medical assistants or dental assistants. OCSs are staff that you use to provide clinical services, but they're not licensed or certified or registered. So your credentialing elements have to include verification of licensure, education and training, completion of the NPDB query, DEA registration, identification of the individual, and basic life support if it's applicable. Privileging elements, and they're two separate things. Sometimes it's a little confusing, but you have to have a credentialing process and then privileging. And credentialing is really checking their background. And privileging is, are they competent to perform services requested, or what are they competent to perform and what can they perform here at the health center? So privileging elements include verification of their fitness for duty, immunization, and communicable disease status. For initial privileging, when they're first coming into the health centers, all you have to look at is to verify current clinical competence, is the training that they've been through, their education, and if available, reference reviews. Once they're established in your health center and they're up for renewal of privileges, the verification has to be through a peer review or other comparable methods, such as a supervisory performance review. And the supervisory performance review should have words in there that discuss competence, like how they're doing. And finally, you have to have a process for denying, modifying, or removing privileges based on their competence or fitness for duty. With the application, you have to attest that you have files or records for clinical staff containing documentation of licensure and credentialing and recording of privileges. You also have to attest that if you have contracts with provider organizations or formal written referral arrangements, your contracts or these arrangements have to include terms or provisions that ensure that the providers are licensed, certified, or registered through a credentialing process, and that providers are assessed as competent and fit through a privileging process.
Right. So just 2 points about this. Number one is the words competent and fit. They added the words fit now. That was not previously a requirement. And so if you have, what this applies to is the example I gave earlier. You're contracting with the hospital center to provide cardiologists. It used to be that you had a credential and privilege a cardiologist yourself. You no longer, based on what we told you last year, you no longer have to do that. You could just have language in your agreement with the hospital that says they're going to do it. But if we did that language for you, then we included competent and fit. But if you just use the words in the manual, you may not have had fit in there. You might need to go back now and modify it. Also, something important relating to credentialing and privileging. So the way it's been working for OSVs is when they come on site, they say they want to see, example of 5 credentialing files, and they've been letting you choose them. In the FTCA manual, they are very clear that they will not let you choose them. They will come on site and they will randomly pick. So the days of, just making sure we have 5 that are really good and forget about all the other ones might still work for the OSV, but it will not work for their FTCA review.
So just a quick reminder and note about the compliance manual. They made some changes to credentialing and privileging. You're not required to employ your clinical staff. You can have contracts with providers or provider organizations to carry out the required or additional services, except that you have to directly employ your CEO or your project director. You also have flexibility to determine who has approval authority for credentialing and privileging of clinical staff. So before, a lot of policies had board approving everybody. That's no longer required for HRSA purposes, but you have to be mindful of any state law requirements. Again, another important change, verification of competence can be done through peer review, or you can use a different method, whichever works better within your health center. And you determine how credentialing will be implemented. So you can have an HR department that makes all the primary source verification contacts, or you can contract with a credentials verification organization to perform the credentialing activities for you. Okay, claims management. So as prior PALs required, you have to attest that you have a claims management process for addressing claims, including medical malpractice claims. And that has to include preservation of health center documentation related to any actual or potential claim or complaint. And any service of process or summons received has to be promptly sent to the Office of General Counsel. So what that means is that as soon as you get a claim or complaint, you have to immediately make sure that the appropriate departments put a hold. Sometimes it's referred to as a litigation hold. They send out a litigation hold and make sure that all of the documents are preserved and nothing is destroyed pending the claim. What's new this year is that you have to upload your claims management process or procedures. A lot of this information is included in risk management plans. There's could be a section on claims management. It includes, as I mentioned, the litigation hold, notice to the risk manager or the claims manager as soon as a claim comes in. But whatever your process is, they'll want to see documentation of it. And we can help you with that if you need some assistance. Like last year, you have to indicate whether you had any claims during the past 5 years. You input it directly into the application. You also provide a summary of your internal analysis and activities taken to prevent future occurrences, but that's only with respect to your closed claims, not any open claims. You have to upload the position description for the claims manager. And like the other position descriptions, it has to clearly detail that claims management activities are a part of the individual's daily responsibilities. You have to attest that you inform patients using plain language that you're a deemed federal public health service employee through your website, promotional materials, or within an area of the FQHC that is visible to patients. They give sample language in the PAL of language that you can use to inform patients, and we usually recommend just taking that language and putting it in your wherever you're putting your notice out using their language.
Right. We recommend you put it on the website. With regard to claims management, just to preempt the questions we get, you do not need to have a full-time claims manager, right? This could be someone who has some other job. It could be the QA director or a risk manager or anybody else. Hopefully this is not, the claims management job that takes zero of the time during the year. You don't have any claims, but if you do, it should not be something that has any significant time associated with it. Also important is sometimes, right, so the plaintiff's attorneys generally do not know about FQHCs and never heard of FTCA and don't know what you're talking about. So they may actually file a case in state court. If that happens, you have two choices, right? The standard choice is you notify the federal government and you have to go into court and defend the case and get an extension and spend legal fees and spend a lot of time and a lot of headache with it. 95% of the time, if you call us, we pick up the phone, we call the attorney, we explain to them about FTCA and about how it's just going to wait 6 months for them to wait for the federal government to come in. And now, like I say, 95% of the time, they agree to just drop you out of the case and then file it with the federal government the way it's supposed to be done, or not even go forward if they don't want to sue the federal government. But you could avoid a lot of problems if you just reach out to us and tell us, look, I got this claim, can you handle it?
Okay. So we're just going to talk briefly now about volunteer health professional coverage under the FTCA. So in 2017, as part of the 21st Century Cures Act, a volunteer, who they call a VHP, a volunteer health professional, may be deemed a public health service employee for FTCA coverage if certain conditions are met. They're not automatically deemed, and in fact, you have to sponsor a volunteer and submit an annual deeming application. each volunteer has to be specifically named, and they are granted deemed status. It's not a blanket approval or deemed status for your volunteers. So during the 2020 deeming cycle, you can submit a separate deeming sponsorship application for your volunteers. And if you want to sponsor a volunteer who was previously deemed in cycle year 18 or 19, you have to include them again in the 2020 redeeming sponsorship application.
So not to sound too, I don't know what the right word is, but it's a lot easier than having to submit this application to pay the person $5 for the year. Now they became an employee instead of them being a volunteer, and you don't have to worry about going through this whole process.
But those of you that do, we will, let's see. So you have to meet certain requirements in order. There are a lot of requirements. That's a good idea.
Right.
So you have to meet certain requirements in order to qualify. The FQHC itself has to be deemed for the period. The service must be in scope. The FQHC must sponsor the volunteer. The volunteer cannot receive any compensation for the service from the patient, the FQHC, or any third-party payer, including insurance or Medicaid. Now, that only applies to the volunteer and not the FQHC. So if the volunteer is providing services on your behalf, you, of course, can bill for the service, but the volunteer cannot, or receive compensation. You can pay the volunteer for reasonable expenses, though.
Okay, so just to clarify my last comment, I don't literally mean pay them $5. We have to worry about minimum wage issues or things like that, but I meant pay them a very small amount.
A minimum wage. So before the service is provided, the volunteer or the FQHC must post a notice at the site where the service is provided, just letting the public know that they're a volunteer, they're a deemed employee, and of their limited liability. At the time the service is provided, the volunteer has to be licensed or certified in accordance with the law. They have to be credentialed and privileged by the FQHC. And since they have to be licensed or certified, residents, students, and interns are not eligible. And the FQHC has to maintain all relevant documentation certifying that the volunteer meets the requirements, including the credentialing and privileging files and a written signed volunteer agreement, which has to include that the volunteer will not receive any compensation and documents each offsite activity for the FQHC.
Okay, so that is the presentation. I know there was a lot of technical information here. So if you, so we got one question in right now about whether podiatrists are covered under FTCA, and the answer is that they are covered if they're an employee. If they are a contractor, then most likely not, subject to circumstances that we could talk about individually rather than through the group. But otherwise they can be. Any specialist can be covered if they are an employee. If you have any follow-up questions, as always, please reach out to us and we would be happy to answer your questions. And thank you for your time this afternoon.